The recording's been started. Sorry to interrupt.
All right, thank you.
Mr. Administrator, thank you. I have, as you know, submitted on behalf of the applicant briefing, an opening briefing for the library. I don't intend to repeat any of that. Questions on that? Substantively, I have reviewed the order that you issued today. Found an 11 iteration matter, which is docket number CC-2021-OGR-01-002. In my list of factors that you established in that matter are reasonable and appropriate. I suggest using this matter.
Mr. Hearing Officer, I'm sorry to interrupt one more time. The audio is very, very low coming from that device. I cannot hardly hear Mr. Christian. I apologize.
I got an idea. Chris, is that any better?
I can hear you just fine. Mr. Christian, would you mind saying something?
Chris, is it any better now?
I can hear you just fine.
Thank you. So the amazing high quality speaker was dying. Right. You centered that. All right. Chris, let's do a real quick test. You hearing me okay?
I'm hearing you just fine.
Thank you. It's a good break, and just regarding taking appearances, initially, I'm just asking everyone to say who they represent, and then I'll call up arguments after that.
Oh, I'm sorry.
So that's fine. So the garble was actually perfect.
Fantastic.
But thank you, Mr. Christian.
Can you go ahead and just identify the docket we're on again?
Certainly.
Sure that was on.
That's important. And I think they were hearing me okay. It was just the speaker was.
Do you need me to re-identify myself?
No, sir. For the record, we are now on the record for docket number CC-2021-OGR-01-002. We had some technical difficulties regarding audio. That's been resolved. I'm in the process of asking folks to identify themselves. Mr. Christian, Representative Snake River, has just identified himself. I believe, Ms. Vega, will you please identify yourself and who you represent? I see Ms. Vega on Zoom.
Mr. Hearing Officer, she is joined as an attendee, so she will not be able to speak in the webinar format. If she does need to be joined as a panelist, I can promote her to a panelist so she's able to communicate.
Please do so. Mr. Piotrowski, can you please identify yourself and who you represent?
Yes, sir, I certainly can. James Piotrowski, Piotrowski Durand, PLLC, representing Dale Verhaeg, Linda Dernancourt, Sharon Simmons, Alan and Glenda.
All right, Mr.
Gray.
Thomas, can you hear me? Or I'm sorry.
Should I continue?
Please, Mr. Piotrowski, we're all family here. Go ahead.
Okay. Yes, we are at this point. Edward and Cheryl Adair, William and Roxy Tolbert, Wendell and Normal Neerman, Cheryl and Richard Addison, Jimmy and Judy Hicks, Antonio and Danielle Anchestegui, Philip and Kathleen Hendrickson, Donna and George Jackson, Karen Altman, Bonnie McGee, Lorinda Schumann, Samuel Butorovich, Tim and Kate Kilborn, and Citizens Allied for Integrity and Accountability.
Thank you, Mr. Piotrowski. Ms. Vega, I believe you are on the line now officially. Can you please identify yourself and who you represent? We'll get it later.
Mr. Hearing Officer, she was promoted as a panelist, but then it looks like she disconnected and rejoined as an attendee. I'm promoting her again.
Thank you very much. Let's just wait a moment.
Okay, she has joined as a panelist, but I show her mic is muted.
Ms. Vega.
Good morning or afternoon, Mr. Thomas. Joy Vega, Deputy Attorney General, appearing on behalf of the Idaho Department of Lands.
Thank you very much for your persistence. Ms. Bonnie, I see you're on the Zoom. Would you please identify yourself and who you represent?
Certainly, Mr. Thomas. My name is Stephanie James Bonney, and I represent the city of Fruitland.
Thank you very much. Are there any other uncommitted mineral interest owners in the proposed unit that plan to participate today? Would you please step up to the podium and state your name and if you represent yourself?
My name's Sharon Simmons, and Piotrowski is representing me as part of that coalition of owners,
Okay,
and I'm here on my own behalf too.
thank you. Thank you very much, Ms. Simmons. All right, now that we have the appearances out of the way, and I think everybody's online and streaming well, I'd like to begin arguments. Mr. Christian, I'd like to invite you to provide argument at this time.
Thank you, Mr. Administrator. I apologize for getting ahead of myself.
Oh, it's fine.
As I've mentioned before, we submitted a briefing on behalf of the applicant. I don't intend to repeat any of that here, other than to answer any questions you may have. I have reviewed the order of factors to be used to reach just and reasonable terms in the other pending integration application regarding the Fallon 111 unit, which is docket number CC-2021-OGR-01-002. And I think those factors are appropriate for use in this matter. I don't know anything about this unit that would cause you to need to depart from those factors. Happy to answer any questions you may have.
Thank you, Mr. Christian. I do have some questions for you. Should factors used to determine just and reasonable terms consider the use of uncommitted owners' lands, including whether a wellbore or pipeline may physically cross the land of an uncommitted mineral interest owner?
With respect to a pipeline, which is effectively a surface use, they may, and in fact, in our proposed form of lease certainly for tracks below a certain size, below a certain size, we have included no drill activity language. In the case of this particular unit, it isn't particularly relevant because we have an existing well and pipeline that crosses either leased property or purchased right-of-way property. So it's a non-factor.
Thank you very much. If a wellbore is already crossing an uncommitted owner's lands. Again, this may be the same answer. Should that physical occupation be addressed, if at all, in this just and reasonable factors order?
Other than to say, well, I don't think so, given that it's going to be at a depth. This, the kick in this well is at a deep enough point that the presence of the well bore, and you can go research this subject, and I have some, but the presence of the well bore, in my view, wouldn't constitute any form of trespass, because it's at a point that the owner would never make use of subsurface. So I don't think it needs to be addressed.
Thank you, Mr. Christian. Those are all the questions I have for you right now.
Thank you.
Mr. Piotrowski, I would invite you to provide argument at this time.
Thank you, Mr. Thomas. I would rely primarily on the written briefing already provided. I think there are 2 points that are worth emphasizing at this stage. First is to come to a recognition of the general nature of the requirement that terms of integration be just and reasonable for everybody involved, but in particular for non-consenting owners. The argument came up in the briefs, and the Snake River Oil and Gas has fundamentally taken the position that as long as they comply with existing statutory law, that the terms they propose are necessarily just and reasonable. That effectively is reading the phrase just and reasonable entirely out of the statute. It is a well-respected, long-term, well-known rule of statutory construction in Idaho and around the country, in fact, that in construing and applying a statute, a decision maker, whether that be a court, an administrative agency, or some other body, should not interpret and construe the statute in such a way that any part of it becomes meaningless. And if all that is required is bare minimum legal compliance in order to ensure that the requirement for just and reasonable terms is met, then just and reasonable terms becomes meaningless. Legal requirement, or legal compliance rather, is required by the statutes that impose particular terms and conditions. Clearly, the intent of the legislature was that in addition to the requirement, the duty of the administrator and the agency to ensure compliance with the law, in addition to that, you were to ensure that the terms were just and reasonable. Thus, just and reasonable necessarily means either nothing at all, or it means something in addition to bare minimum strict legal compliance. And so your job, Mr. Thomas, is to ensure that in addition to meeting all of those statutes, the application for integration requires terms that are just and reasonable. The other point, the second point I would make is that having read this morning's order from the other case, there appears to be, there might be, I'm not sure yet, but there might be a failure to recognize a critical portion of the relevant statutes here. The presumption of Snake River Oil and Gas, and it sometimes appears the presumption of either the administrator or the department or the commission, is that in an integration situation, those who have not previously consented to a lease of their mineral rights will be limited to receiving only a 1/8 royalty and a bonus payment that is no less than the highest bonus payment made prior to the application for integration. That is not, quite frankly, the state of the law. The law provides, the statute provides that after integration, there will be 4 potential status that a mineral owner may be in: a working interest owner, a non-consenting working interest owner, a lessee or lessor, I forget which one that is, but somebody with a lease, and somebody who's deemed leased. In Idaho Code section 47-320, subsection 3, subsection C, the statute provides an owner may enter into a lease with the operator of the integrated spacing unit under the terms and conditions in the integration order. The owner shall receive no less than 1/8 royalty. That is directly contrary to deemed leased individuals who are by statute compelled to accept 1/8 royalty, not no less than, not no more than, but precisely 1/8 royalty. And so in this case in particular, where there are a large number of non-consenting orders, where there is a bit of a history on this particular tract, it is appropriate. And one of the factors that you, I believe, must consider, sir, is whether those who choose to enter into a lease after the date of the integration order, but before the expiration of the time in which owners are given an opportunity to consider their response, the administrator must determine what royalty rate, not less than 1/8, shall those people be entitled to enter into a lease for. This was set out in the briefing as a discussion of what royalty rate shall apply. In the prior case, with the order issued today, I believe the administrator took an improper position, which is to say that he had no power whatsoever to establish compensation terms, since those were necessarily established at 1/8 royalty and a bonus payment no less than the largest amount paid to a leasing owner. There is a third option for those who choose to enter into a lease during a particular time frame on terms which are to be set by you in the first instance, obviously subject to appeal to the commission, at no less than 1/8%. No less than, of course, necessarily beyond any reason implies it could be more than 1. And I believe that's one of the factors you should be considering at the hearing in this matter. It's especially pertinent here, again, given the history of this particular tract and the integration of this tract. Beyond those two items, we would rely on our briefing in the matter, and of course, I'd be happy to stand for questions.
Thank you, Mr. Piotrowski. I appreciate your input today. I have a few questions, and actually a question I forgot to ask Mr. Christian. I'll ask him during his rebuttal. Do you think the existence of the Fallon 110 well should be accounted for in factors for this unit?
Mr. Thomas, I believe that it relates to it certainly should be accounted for in establishing working interest shares. This is not, as Snake River Oil and Gas likes to claim, a wildcat play. This is an existing well. It's already known to produce hydrocarbons. They bought it. They didn't drill it. They bought it at a discount in a fire sale following a bankruptcy. All of those things should be considered in establishing the just and reasonable terms here. Obviously, Snake River Oil and Gas hopes to take this very inexpensive property they purchased and generate as much profit as possible. That is their reason for existence. But that should also go into consideration as to what is reasonable in protecting the other interests of the people involved, other mineral interest owners, the potentially other operators. As we know, no operator can be assumed that they will remain in perpetuity, as well as the general public, and specifically including the municipal interests involved here, since those are a factor in this case. But yes, the existence of the well is a factor that you should be considering in your decision making in this case.
Thank you, Mr. Piotrowski. I have one more question for you. What role do you think an integration order plays in water resources? How do you believe a proposed factor for an integration order would interact with requirements that are already in rule for groundwater monitoring?
The existing protections for groundwater that exist as a result of other statutory schemes and as a result of the generalized law of water use in Idaho exist independently. And so what we are doing in this case is we are adding yet another factor to that mix. So for instance, the work of the Department of Lands, the work of the Department of Natural Resources, a number of other agencies, as well as the work of irrigation districts, water companies, et cetera, are all designed to meet the needs of their particular industries and their particular programs. None of them should be assumed to be responsible for or to be taking appropriate measures to address the possibility of harms to groundwater arising from oil and gas exploration and development. Accounting for those harms and those risks and preventing them is uniquely the job of the Department of Lands and the Commission and the Administrator for Oil and Gas Conservation. In other words, the unique threats posed by oil and gas development must be addressed, in my opinion, by the agency that is put in charge of regulating those particular processes. We should not be relying on agencies that exist for entirely different purposes, pursuing statutes that exist for entirely different purposes to address the critical need of protecting water resources in Idaho.
Thank you, Mr. Piotrowski. Those are all the questions I have for you right now. I would ask if there are other uncommitted mineral interest owners in the room who like to provide argument. Again, if you're represented by Mr. Piotrowski, that's fine. Please come up. State your name.
Linda Derncourt. Linda Derncourt.
Thank you.
First, let me say that I am not against oil and gas. Am I supposed to go ahead and do my,
Go ahead.
go ahead?
You'll do
Okay, thank you, because I have a doctor's appointment I have to get to.
Well, that's fine.
Okay, I'm not against oil and gas. I drive a car, I heat my home with gas, but I do believe it should be done responsibly and safely. I am worried about lines under the water treatment plant, lines under our rivers. What happens when something happens to those things? I attended the meeting on May 20th for the Barlow, and when Snake River spoke, they referenced case law and regulations in other states. My feelings are, if I wanted to be regulated by those case laws and those regulations, I would have moved to those states. I moved to Idaho under your regulations and your case law. Mr. Brown was here and he was complaining that it was taking way too long to get through this process. It was over a year. Well, in response to Mr. Brown, I worked from the time I was 16 till I was 63. That is a long time. I took my retirement money, bought a lot, including the minerals, hired a contractor, and had a house built for retirement. What is going to happen when my groundwater gets contaminated? What is going to happen if the water treatment plant gets contaminated? What's going to happen if my house starts sinking into the ground and the walls start cracking? I'm too old to start all over and walk away from a house that I spent my entire life working for. And please don't tell me that I can sue Snake River. I know what will happen. We'll all sue, they'll file bankruptcy, they'll pick up their stuff, they'll leave, and the taxpayers of Idaho will have to clean up their mess. Don't tell me it can't happen. I lived in California for 60 years. I know what happens when things go bad and how bad they can get. Your job, Mr. Thomas, is to protect the citizens of Idaho, our natural resources, which includes our rivers, our water, and our air. Please listen to what the taxpayers in the state are saying to you, rather than to an out-of-state corporation. Thank you very much for your time.
Thank you, Ms. Delacourt. Next, I'd like to invite Ms. Vega to provide argument on behalf of the Idaho Department of Lands.
Thank you, Mr. Thomas. Joy Vega, Deputy Attorney General. The Department of Lands did file an opening brief in this matter. The intent of that brief, as stated, was to provide easy reference for you to applicable Idaho Code sections, administrative rules, and other contract-based considerations that may be necessary or relevant to you in determining what factors are just and reasonable in this particular matter. I don't have any specific argument And I certainly don't want to restate what was presented in writing. So unless you have any specific questions, the department would just rest on that opening brief.
Thank you, Ms. Vega. I don't have any questions of the department. Ms. Bonnie, do you have any arguments to offer today?
I don't, Mr. Thomas. Thank you.
Thank you, Ms. Bonnie. At this point, I would invite Mr. Christian and representing Snake River to come up and offer a rebuttal. And if you don't mind, before you did that, there's a question that I promised you that I didn't ask first time.
Certainly.
There is, as discussed, there's a well already drilled in the unit. Should a factor address that?
I mean, I don't mean to be flippant, but I want to ask your question with a question, which is in what way, if you mean in terms of what compensation should be provided to uncommitted mineral interest owners, I think the answer is no, for a couple of reasons. One is it's contrary to what I think Mr. Piotrowski suggested, it's the lightly tested well. We don't know as we stand here today how it's going to produce in the long term. Secondly, if the suggestion is that because we have this great well, and we know it now, that uncommitted mineral interest owners should be provided with a better deal, that to me suggests that holding out will be encouraged, which I think is antithetical to the intent of the statute. The idea is to encourage production and to regulate in a way that allows operators to responsibly get to production, and encouraging holding out will produce the opposite effect. So for those reasons, I think the answer is no.
Thank you, Mr. Christian. I'll go ahead and let you start with your rebuttal, please.
I have only, a couple of things to say. One is, Mr. Piotrowski is correct. The statute says royalty of not less than 1/8 in one circumstance. But I think that, for example, one of the factors that you indicated you're going to use in the fallible 11 unit, which is, how does this compare to voluntary agreements within and around the unit, cover that situation. We can examine whether anybody else in the unit is getting more than 1/8 on a voluntary basis. And I think the answer in this case actually is no, across 100 or whatever owners. But I think you can craft a factor that deals with that situation. With respect to the question of who deals with water, I would suggest that Mr. Piotrowski's offered you kind of a false equivalence, in that you have the department has its own set of rules which govern operations, from drilling to cementing and casing to well treatments to production to reclamation to plugging and abandoning, and all of those things it can do to be protective of the environment and of the safety of those near the well. That does not mean that other agencies like DEQ or the Department of Water Resources do not also have their own sets of rules that may or may not apply to this setting, which they can administer. So I don't quibble with the idea that there are multiple jurisdictions at play where oil and gas operations are concerned. And I don't think it's appropriate for the department to, in an integration order, attempt to define and administer rules of other agencies that deal with the subject. And then the last comment I would make is on the subject of what is compliance with the law enough. And I think the suggestion was, just and reasonable has to mean something, and it must mean then that you imply other terms. And And I think and the answer to that is, as you did in your order in the other matter, go back to the 1963 version of the statute, which had the words just and reasonable in it to begin with. And what it clearly referred to was, alternative economic terms. And which is kind of the point I've been making through briefing in the last two matters. And since that time, the statute has been, to the extent it's been changed, it's been narrowed. The alternatives have been more defined, whereas before it was very general. You have to offer a number of just and reasonable alternatives. And the basis and compensation, have to fall within that term. Now we have defined alternatives. The words just and reasonable have been taken out of the statute. They were there already. There's no indication that they mean anything different than they did back in 1963. It's just that the statute has been taken from here to here, which to my mind means you're still dealing with the same issue. What's economically fair to uncommitted mineral interest owners in the context of compensation for minerals as compared to those who've leased their minerals? It doesn't mean that just and reasonable now means, the entire universe of potential subjects one could address in oil and gas. And that's all I have.
Thank you, Mr. Christian.
Thank you.
Okay, folks, the arguments have been made. And Chris, I'm gonna lean on you a little bit here. I would invite anyone who signed up to provide public comments to do so at this time. First, is there anyone in the room who signed up to provide public comments who would like to do so? Okay. You're welcome to come up if you'd like to say something.
Can I, even though I didn't already ask to speak?
There's not a line in front of you, so go ahead and walk up. It's okay.
Okay, great. I'm glad to see you're being reasonable. Okay, my name's Sharon Simmons. I am an uncommitted mineral owner, and I am very concerned over what has already happened, what has already been allowed, and to say it's just and reasonable for $100 an acre, you could have your water contaminated for life. And if that happened, these Texan cowboys, they would be out of here in a heartbeat with a bankruptcy, leaving the Idaho property owners with their hands, like I'm absolutely positive my place would be worth very little if the water was contaminated. There's history. You guys want to go back to history where this state, that state, this state, well, in Pennsylvania, they did drilling there, contaminated the water. Those people cannot use their water. So they have to truck it in. And that's not good. I'd really just like you to think about, okay, now they're discussing what's reasonable for a payoff if it comes to be. Well, great. What's reasonable if our water's destroyed? As an owner of property, and I'm much like the other lady that spoke, it's everything I have. And if it goes down the tube, I won't live long enough to argue it out, because the system is almost encouraged. I think it's a little good old boy system with the attorneys that let's drag it out. Let's drag it out. We don't make enough money if we just solve this. So let's drag it out. I think in Pennsylvania, it's going over 20 years on time. So, and I'm concerned over my investment, that there's nothing behind this to back us as landowners if they contaminate our water.
Thank you.
I think you can't guarantee that.
Thank you. Mr. Gozo, is there anyone online who signed up to provide public comment?
For this webinar meeting, Mr. Hearing Officer, we've got only one other individual who's an attendee. and that is Richard Brown, and the rest are all panelists.
Thank you, Chris. Let's go ahead and do what you can to help Mr. Brown provide comment.
Okay, I'll go ahead and promote him to panelist. Mr. Brown is now a panelist.
And I'm unmuting. Good afternoon, and I just wanted to comment in regard to, there was comments about us being all out of staters, and if something went wrong, that we're all going to run for the hills. And I do appreciate both of the testimony from the two parties regarding care of their water. And one of our employees is there, Wade, is in the room. He is an Idaho resident. I personally am now an Idaho resident, and I am the owner and manager of Snake River Oil and Gas. Live in the state of Idaho and plan on remaining in the state of Idaho. And we're trying to be as transparent as possible. I'd be glad to sit down with anybody who wants to talk about. We've presented extensively in front of the city of Fruitland in regard to our care of the water. We will not be under the water treatment facility. The well site is west of the river. Excuse me. I said that well site is east of the river. All product will be moving eastbound from the location. So we do not plan, and we have all kinds of protections in place to avoid any product getting into in any way infringing on this water supply or the river itself. We've got berms. We've got multiple they're redundant safeguards in place that are required by multiple agencies. And I would comment as to other states. Idaho, we operate in multiple other states. Idaho's regulations are the most stringent of any oil and gas province we currently operate in. So that's really out of me, but I'd be glad to sit down with anybody and go over those things. And I am here, and I'll be glad Wade is there, and he'd be glad to give his number or my number if somebody would like to visit with us outside of the setting. Thank you.
Thank you, Mr. Brown. I'd also like to thank everyone for participating today. I will take this matter under advisement and issue a written decision within 30 calendar days of this hearing, which I believe is July 21st. This adjourns our hearing. Thank you very much. Mr. Goza, you can stop recording.